So some of the non-immigrant categories. The typical students who come to the Massachusetts area by the thousands come on an F1 visa generally, sometimes on a J1 as exchange, so like the high school kids come as exchange students, some college kids for a year abroad. So there's a lot of scholars and visitors who come on that. B2 is the regular visitor or a tourist, the person who comes for pleasure. And this was the category where the boycott erupted. There were people coming in for two major events. One was the International AIDS Conference, and they were caught because at the time that AZT was discovered in their baggage. A number of them were trying to come, after having been in Canada for a little while, they were trying to come down to a conference, and they were stopped by the, at that point it was the Immigration and Naturalization Service. Their bags were looked at, they found the AZT, and they blocked them. And there was a big to-do about that. The other one was the gay games. The international gay athletes were coming in, and they were caught similarly and blocked. And it got very ugly. The boycott has lasted on the International AIDS Conference for 15 years. What the administration did back then, this is like 15 to 18 years ago where this was all brewing, was they came up with a 30-day waiver. But you had to declare that you were HIV positive, had to be screened medically, then had to apply for the waiver. When you came here, you couldn't extend and you couldn't change status. So it was a really ugly waiver process and not worth much, and as a result, not widely used. There's also people from, I think, 34 different countries that can come without a visa. They call them WTs, waiver tourist or visa waived. H-1B professionals, this is you'll see in the newspaper a lot too. These are the people who have at least a bachelor's degree, often more. They're sponsored by a U.S. employer. It's huge around here with the hospitals and the scientific research community. But it covers everything from language teachers who are in short supply, or architects who are involved in projects being built here and abroad, and on and on. The numbers have dropped dramatically in using it, as you would expect they would. So it really hasn't favored foreign nationals, as the politicians say. This year the numbers have not even been used, and we're 8 to 10 months into the visa year. So it's risen and fallen with the economy of the United States. It really doesn't favor anybody. If anything, it helps bring skilled people here who are in some short supply. L1s, transferees between companies, either American or foreign, branches, subsidiaries, affiliates, moving back and forth. O1 is used in this area, probably more than many other areas of the U.S., for persons of extraordinary ability. Can be in the science, in the arts, and in music, but it's very often used in the sciences and medicine. So the hospitals and the medical schools and the research facilities use this. And then there is a victim of crime who assists in prosecution. This is only about 4 or 5 years old. It's become rather significant with the number of people who have been brought in certain trafficking situations. They're being exploited sort of as slaves, oftentimes in terms of drugs and prostitution, etc. But it also can be of anybody, any foreign national who's not here legally, who is the victim of crime, who assists in the prosecution of the perpetrators of the crime, and then they need support either by the police or the prosecutors. So those are some of the non-immigrant categories. It goes from A to W, I think, at this point. Congress just takes the next letter available and creates a new category to fit a particular need that they define. All of these people are here temporarily. The person on an H can stay for 6 years. The visitor can usually stay for 6 months. So the terms of each category, what you can do, how long you can stay, whether you need a visa, who you apply for, whether you have to leave or can extend, are written into the law and the regulations, and it's a detailed, long compendium. The one that I want to go on to a little bit further than are the permanent resident categories, because again, this is where the HIV waiver and the screening process, the medical exam, came up in big ways. And the categories are family-based, which I'll go into in some degree, employment-based, that is a U.S. employer wants to sponsor you to be here. The diversity lottery, at one point the law was really racist, and it basically allowed only Europeans in. And that's gone through major revisions over a 150-year period. When it finally became a whole world policy in the late 70s, a number of the people who previously had all the benefits claimed that there had been discrimination. It's a little ugly. So Congress ended up creating this lottery just for a few of them, and claimed it was to reconcile the discrimination against these people who previously had all the benefits. So the history of it is rather ugly, but right now it's fairly good. It's for people from any country where there isn't a big flow of people into the United States. And every year or two they determine where the flow is. So Canadians are never included because the flow from Canada is very big, or Great Britain, or Mexico, or Jamaica, or Haiti. If there's a large flow on a regular basis, you're not eligible to apply for one of these 55,000 numbers. But if you're from a country where there isn't a traditionally high flow, you can apply in this lottery, and it opens the possibility of bringing people from more diverse backgrounds. So it's gone from sort of an ugly political step to benefit a small group of white people to a fairly open, progressive lottery. My guess is this will be eliminated in the reform because the side that doesn't want many aliens here is going to use this as one way to chop numbers. But anyways, we have it right now. Investment, if you got $1 million and you can create a business, hire 10 American workers, you can get residence in the United States. Asylum and refuge, I've explained a little bit, I'll talk more. Cancellation of removal is basically if you're in deportation proceedings, what they now call removal proceedings. You can try to block the removal, and I'll explain that. And then registry is a strange piece of law that I'll mention. From time to time, there are others, like the Cuban Adjustment Act, only for Cubans. It's been on the books, I think, since 1962. It's very peculiar politically. It hangs on when most temporary laws come in for a year or two and then disappear. VAWA is very important, Violence Against Women Act. If you suffer violence at the hands of an American spouse, you can apply for protection. This has had a history that's been sort of mixed, but basically right now it works really pretty well. The Vermont Service Center handles applications from throughout the United States, and it was designed to not give the U.S. spouse this tyranny over the foreign national spouse, usually a wife, because her status was dependent upon the marriage to him, and it resulted sometimes in very abusive, still does, in very abusive situations. So VAWA was written to correct that. It also covers children, and it's a progressive, wonderful piece of legislation. So the family-based categories. If you are sponsored by a U.S. citizen, then you can be a parent, a spouse, a son or daughter, married or unmarried, or a sister or brother. That's only if you're sponsored by a U.S. citizen can you be in any of those categories. If you're sponsored by a permanent resident, it can only be a spouse or for an unmarried son or daughter. So if I'm a permanent resident, I file for my daughter and she marries, the category is dead. So you have to remain through the life of the sponsorship valid in either one of these categories. There are some within that who are called immediate relatives, and that is that most people get into long lines in these preference categories. Some immediately come to the top of the line, and they're immediate relatives. And that's the parent, spouse, or unmarried minor child of a U.S. citizen. In order to get that sponsorship, the citizen has to be 21 as a parent or a brother. Well, brothers and sisters not here, but the U.S. citizen has to be a parent if they're 21 years or older if they're sponsoring the parent. There's no annual quota. And if they're here, they can apply for permanent residence without leaving the United States. The law prefers people to go out and apply at the embassy, but there are people who are allowed not to sort of get around that, and that is if they've been inspected, admitted, or paroled in, they can apply for adjustment of status to residence here, even if they violated their work status or their